network, and she has served as faculty member of the Bangladesh International Mediation Society. She currently serves on the panels of Shanghai International Arbitration Center, Tanzania Institute of Arbitrators, National Construction Council of Tanzania. She also acts as an arbitral secretary in complex arbitrations. So presenting Madeline, she will be today presenting a session on role of lawyers in mediation. Madeline.
Thank you so much, Asha. Thank you for the introduction. I'm just trying to put my presentation in the laptop that we're using. Yes, my name is Madeline. It's a pleasure to be here this morning, this afternoon, to present to you. Okay, so that's working. Thank you. So I'll be presenting a very short paper on the role of lawyers in mediation. I've been listening very attentively to the presentations that have been given prior to this presentation, and I came to realize that we're in a room full of lawyers. Yeah? So my first question to you is that what role do you play in your daily professional life as lawyers? Can anyone tell me? Okay. What's your role as a lawyer? When you get a client briefing, what's your first initial piece of role that you play to your client briefing? Yeah? Do you want to tell me? Okay. Who wants to tell me then?
Even though I'm not a lawyer, I'm a law student.
You're a law student.
Yes.
Okay. So there's certain who are in the room who are law students? Still law students?
Yes.
Okay, so then look at it in a different light. You're a law student. What are you being taught to do as a lawyer? Represent your parties, right?
Yes.
Read your statutes and interpret your laws, isn't it?
Yes.
Okay, when you're representing your clients, how do you represent your client's case? Are you taught this? Right? You understand, you get the information from your client, meaning the briefing. What has occurred, what is the dispute, what is the nature of dispute, isn't it? And then what goes on about there? You create a strategy, right? What's your strategy usually? What would be your strategy as a lawyer representing your party? Any law student who wants to answer that question? Is it fight to win or win to fight? Fight to win, right?
It's just a compromise, or it's just a negotiation.
Do you want to compromise your party's position
No.
in court?
You want to fight for your
Okay.
interests? The party doesn't come to you to
No, he doesn't come to you to compromise. What does he come to you to do? To defend him. To use the law in his defense. Right? To use the law to represent his rights, right? And interests. Is that what we're trained to do when we're in law school, right? This is the mindset that we have as lawyers. That's the mindset I have as a lawyer. I've been trained to defend
fight for my client.
and fight for my client. You understand? So that this is what we're trained to do. Now, how then does this role shift when we're in mediation? This is what I wanted to present today. But prior to that, I wanted to define mediation. I know Priyanka has gone through a very, a good definition, which I actually also had, because I like to rely on the figure. It's a UK-based training, center? Yeah?
Non-profit.
A non-profit center. And their definition, as looked at by Priyanka, it's pretty much covering nearly every aspect of what a mediation is. It's a flexible process, it's a confidential process. A neutral person facilitates the negotiations, right? For the parties to reach a negotiated agreement, or the mediated negotiated agreement, isn't it? And at the end of it all, the parties are in ultimate control of the process. How beautiful is that, that you remain in control of the outcome of your dispute? Isn't it wonderful? Because when we go to the courts, who is in control? Can anyone tell me? When we file a matter in court, we've got our pleadings in court. Who are in control?
No.
The judges? Who are in control?
The lawyers are the first
Leaders.
people who are in the control of your matter.
Leaders.
You go
Sorry?
through your lawyer.
Leaders or lawyers.
Yes,
Pleaders.
he's correct.
The pleaders?
Leaders or, yeah, as a lawyer.
Yes. But who is in
Leader.
control of the decision or the outcome?
Judges.
The judges.
This court.
So this is a definition that Priyanka already went through, but this is what I usually use as well. So whenever you need a reference point, you could always go to the CEDAW website and obtain a reference from there. I also had a Black Laws Dictionary mediation definition. And that one went on to say the act of a third person who interferes between two contending parties with a view to reconcile them or persuade them to adjust or settle their dispute. You see? It goes on to talk about that third neutral party. And then if you go on to Riskin's definition of mediation, he goes on to say a process in which an impartial third party who lacks authority to impose a solution helps the others resolve a dispute or plan a transaction. So a mediator can really be involved in either a dispute occasion or even during the negotiations. Yeah? When you're negotiating a huge project, infrastructure project, you've got different parties from different walks of life, different worlds. You're maybe a public-private agreement where you have the government and the private sector. A mediator, or sometimes called the negotiator, yeah, could play a very pivotal role, yeah? So anyway, I'll skip straight to my presentation because we do now have a sort of feel of what mediation is, right? Now, if we say that it's a flexible process, yeah? Do we then use statutes? Do we use precedents? Do we use the adversarial way of doing things? The traditional role that a lawyer would play?
Not really.
Not really? Really? Huh?
But if the facts
Do you
are
have a role to
similar,
play?
then they can take those case laws into consideration.
Okay, so another question. Do you have a role to play as a lawyer in mediation? Do you feel you have a role to play? Yes, you do.
But
You do
I'm
have.
a neutral person, right? But if I mean to say that if the facts are similar, then I can consider those cases or statutes.
Okay, so you would not consider a mediation case a
No,
case
not
that
in the
you could-
first place.
Not in the first place. Okay. So then the message should be switching now in your minds because you do have a role to play as a lawyer. You have a very pivotal role to play, very crucial role to play at the outset of your client's dispute having arisen or so on. Or even at the initial stages of your client getting into any arrangement of a contractual nature, where you have to advise your client. How then would you resolve a dispute if it does arise? Because as lawyers, we work as risk mitigators, isn't it? And as a risk mitigator, when you're reviewing your contract, before your client signs your contract or his contract, there has to be a particular clause. Do we know what this clause is called in your agreements? Yeah? A dispute resolution clause. Now, how do you get mediation in there? We usually see arbitration, right? We see amicable efforts will be made between the parties. But do we see a clause binding the parties to attempt to mediate? There are clauses such as that, where you have a multi-tiered sort of process. So it would start off by saying that if a dispute arises, or if a dispute arises in connection with this agreement, yeah, the parties will, one, try to amicably negotiate between maybe the executives of the companies. If they fail to do so in maybe 21 days or 14 days, then they will submit to a mediator for mediation. Yeah? So as time goes by, we've seen a lot of transition to institutionalized mediation. Yeah? So if that clause is an institutionalized mediation clause, it will refer to the Bangladesh International Mediation Society for them to either use the rules of the BIMS mediation rules, yeah, or submit to BIMS for them to appoint a mediator. Correct? So that's when the lawyers come in at the very outset, when they're negotiating their contract. Right? And advising your client whether to submit to an institution such as BIMS is very important because one, it's a local entity, isn't it? A local society. They will get access to a local mediator who has been trained. Yeah? So a dispute arises within their framework, their contract, they could be able to submit to such institutions. Now, for many lawyers, the threshold questions are whether they should attend the mediation at all, and if they do, what role they should take in the sessions. Yeah? You spoke of you having no role, but there is a role that you can play. Lawyers as peacemakers. This is a quote from Abe Lincoln from his Notes on Practice of Law, written in 1850, and actually also quoted by Warren Buffett, who she quoted from with regards to the fact that we really do need a channeling of disputes in a different form as opposed to the courts. As a peacemaker, the lawyer has a superior opportunity of being a good person. There will still be business enough. What has staggered the world of mediation? What has staggered the growth of alternative dispute resolution in Bangladesh? Is it the lawyers thinking that they will not have their fees? Yeah? That's really at the end of the pinpoint of that message. We still feel that the lawyer's role will no longer exist, that mediators will replace judges, that mediators, and so on and so forth. So this is a fear that we need to overcome. Yeah? I spoke about our traditional role, and really it's an adversarial system that we work in. This is a common law system, similarly to my country, where we have a common law system, and lawyers really, we play that adversarial role in the sense of presenting our pleadings. Yeah, there's a written statement of defense. There's, we have the civil procedure court. Yeah, the hearing will be held. Parties will hear, the judge will hear both sides of the dispute, and so on and so forth. But however, the vital distinction is that mediation is a non-adversarial process, if you look at the last sentence there, through which each party is encouraged to take responsibility for resolving the dispute. At the very beginning of it all, the lawyer's job, prior to even going to the mediation, is to be able to advise his clients that mediation is the right process for them. And in order to advise them, they need to also highlight the key advantages, which we saw from the presentation also made by Priyanka, the key advantages of mediating. They need to understand that it's a confidential process, and that could work to their benefit, right? Certain companies don't want to share maybe trademark secrets or or business acumen that they have acquired, and so they would prefer a process such as mediation because it would not be made knowledgeable to the public, isn't it? So if you advise your client that actually your dispute, since you're pushing back from going to litigation, mediation could be your saving grace, isn't it? Then, So I've spoken about the fact that it's a non-adversarial process, non-litigious. Mediation, you engage a collaborative problem-solving technique. We've heard a couple of our speakers talk about collaboration. How do you build the collaborative environment in a mediation room? That is the technique, which is a shift from being adversarial to being a more collaborative lawyer, yes, in the mediation process. So you're from advocate to advisor. You also play an advisor role as a lawyer during the mediation, because you need to advise your client on the legal nature of things. Yeah? You need to advise your client on the legal aspects of his dispute. Okay, so refer to the mediation. A party who chooses to resolve a dispute through mediation may or may not be represented by a lawyer at any point in the process. So the party may opt to not have a lawyer present. There's some disputes where they wouldn't prefer a lawyer present, but it depends, of course, in each circumstances of that particular case. At the option of the party, for example, a party may be represented by a lawyer from the moment that the party's first pleading is filed, enter the case unrepresented, and secure representation at some points later during the mediation process, complete the mediation process and consult a lawyer after, only to review the terms of the mediated agreement, to make sure that they align to the local legislation, then complete the mediation process and enter an agreement without a lawyer present. So you could come in at any point. Yeah? Before the mediation, we spoke about you advising your client, encouraging them to take part in the mechanism, the mediation mechanism, encouraging him by highlighting the advantages of the process. Make sure that he makes an informed decision before entering or the process begins. The lawyer then has to explain the nature of the mediation process. The parties need to understand that there's certain process or techniques that the mediator will adapt, which is different from the courtroom. So he shouldn't be shocked when the mediator remains in a room with the parties without the other party present, right? With one party without the other party present. So you need to create that awareness to your client so that he doesn't feel, that the process, maybe the mediator is being impartial, yeah? And so, what about the fact that the lawyer would need to be able to, what was my point? I think my point just flew off. But anyways, when it comes back, I'll touch on it. I think it's on my, there, my piece right here. 5 minutes? Gosh, I've got 5 minutes left. Okay, so the lawyer assists the party in determining whether timing is a factor in choosing a mediation. This speaks to the point where is the conflict or the dispute ripe enough or beyond even trying to mediate? You understand? Because at some point there's a conflict continuum of some sort that sort of gives you the point of which is the right point to mediate. But of course, one cannot say there's a right point to mediate, actually, because it could be done at any stage during that conflict. However, if it's gone to the end of the continuum, where parties are actually in fight mode, it could be difficult to arrange for a mediation, for the parties to agree to a mediation. Then the lawyer advises the party on the substantive law, which we've spoken about. What about preparing for mediation as a lawyer? This is very important because we find that lawyers would walk in with their clients unprepared. Have you done a risk analysis of your case? Yeah? Explaining the nature of mediation, as we spoke about, to your clients prior to the mediation. Identifying your interests, your client's interests, and also developing strategies to achieve a final outcome. These are the roles that that a lawyer would need to play, because the client would not be able to do this without their lawyer's insights. Yeah. I spoke of the decision tree because I think it's very important for a lawyer, and I use it in my practice pretty much every day. When you're advising a client to go for mediation, this is a very good simple decision tree that you can adapt. You tell them, if you go to court, this one doesn't have the court, but basically, if you see the liability coming down from, if it's a yes, expected value of is 28,000 US dollars. If you see the liability is 30% no, that they will be having no liability. If it goes 70%, yes, they're liable. What about the damages there? Right? It goes up to 70%, to 20% being 70,000 US dollars, or against VFV 60%, which is 40,000 US dollars, and 20% being 10. So circles are the chances of success, right? The chances of success. And the expected value of this claim is 28,000 US dollars. Yeah? So then they'll get the gist of it. If I go for litigation, I might end up on the 70,000 over there, right? And the 60% of 40,000 US dollars. So it's best that you do a decision tree for your client. Then there's this pre-conference meeting with your mediator. Usually the first one is with the lawyer. You agree to the mediator's fees. The mediators get paid, right? So there would be need for you to consult the mediator on their hourly rates. Also plan for the date, the place, who will be attending. All these are discussed during your first mediation conference. If there's going to be a second one, you can involve your client. Your client can be there, because it also builds that rapport. It starts to build the rapport with the particular mediator you have engaged. The mediation brief, or sometimes called a position statement. This is very important. This is also your opening statement. So if you're a lawyer representing your client in a mediation, at some point during the opening of the session, the mediator will give you an opportunity to do an opening statement. Your opening statement is also probably going to be your mediation brief or position statement. Yeah? And that's really just stating the facts, the issues, and the goals from the client's perspective. Any limitations, and how that mediation should be structured. So some sort of a mediation plan. Especially in a complex mediation, a mediation plan is very important so that the timelines are observed by both ends of the process. So I won't go through a lot, but I'll share the slides. What about attending mediation? We spoke about the fact that you can attend, and sometimes you don't have to attend. The parties maybe could represent themselves. The skills that you require as a lawyer: persuasive, good communication skills, good negotiation skills, because you'd be playing the dummy, right? Where you're conveying the message to your client, so that your client can understand the position that they're having is probably not as good as it seems, right? You're negotiating so that they're able to be persuaded to shift that dynamic, yeah, and be able to reach a consensus. The offers and settlements, they could go through you as the lawyer representing your client. So certain offers will be made by the other side. You can assess whether they're practicable or reasonable to your client. And also this will allow you to be able to draft the settlement agreement. You'll be drafting the settlement agreement. Sometimes some mediators like to draft them themselves, but usually the lawyer also has to look over them. Make sure the terms are in accordance to what has been discussed. Yeah? Make sure that your client is making an informed decision prior to signing the mediated settlement agreement. Sometimes other parties may withhold information during the mediation, and because the mediator is bound by confidentiality and maybe may have come across such information during a caucus, meaning the stage where the mediator uses different a room to discuss with one party the dispute, he may come across some information that he hasn't shared with the other party. What happens in that situation? Especially if the mediator is also a lawyer and comes across an issue which needs to be reported to maybe the professional bodies out there, maybe the financial crimes unit or so on and so forth. So make sure that your parties are making an informed decision. Signed by all parties, and of course, what we like playing the most is witnessing the documents, right? Getting your stamp on there and making sure that it is attested, yeah? What about post-mediation? As a lawyer, yes, Mr. Okay. As a lawyer, it varies from jurisdictions to jurisdictions, right? Some of our jurisdictions allow for you to be having a mediated settlement agreement that is enforceable, and some don't. So, and some jurisdictions also have reporting requirements. For example, in Kenya, once it's mediated by a court and next mediator, the court and next mediator has to report back to the courts, as to what has transpired. Maybe a mediation has been settled, and so they report back. But also, of course, there are certain issues that could be played by a lawyer, in the sense of what kind of information that lawyer reports to the courts needs to also be monitored, and that's where your role as a lawyer also may take play. So, no questions. But, thank you for listening.
Sorry about that, Madeline.
It's okay.
It was really an interesting session, but I'm really sorry.
Thank you.
So, friends, now we break for lunch and we reassemble at 2 o'clock.
Yeah, one small thing to add what Madeline told about role of lawyers in mediation. There is a very famous quote given by Mahatma Gandhi in his autobiography, page number 133 and 134. Particularly for lawyers, it's very interesting. He has quoted, both were happy over the result, that is the parties, and both rose in the public estimation. My joy was boundless. I had learned the true practice of law after trying mediation. I had learned to find out the better side of the human nature and to enter men's heart. I realized that the true function of a lawyer was to unite